policemen get to the crime scene, they have to take their evidence or their possible evidence or the clues to the crime laboratory. This is where you have all these scientific devices that do all kinds of different work that enable you to get some conclusions about who did the crime or what kind of a crime it was or all kinds of things. Now, it's not an ordinary science laboratory because there's all different kinds of devices and tools they use. It's not like a chemistry lab where you only have chemistry stuff. You might also have bullet analyses in there. It's not a biology lab where they work on samples of live cells because they might even need to do computer imaging or something like that. So there's so many different types of analyses that are required for forensics. In fact, that there is no single crime laboratory. And different crime laboratories specialize in different things, and they have certain different tools and different machines that can do all kinds of different analyses. So there's no one single crime laboratory. And what happens is that you send off your evidence for whichever crime laboratory has the tools that you need, like for arson or for DNA analysis. You send it off to whichever lab is most convenient and actually has the tools to do the analysis. So they finish the analysis, the forensic analyses, and they've got to bring it to court to say the person's guilty or innocent or whatever it might be. So what's allowed in a court? Because ultimately that's where all the forensics conclusions will be debated in a court. What kind of evidence is allowed in a court? First of all, they certainly allow witnesses. They've always allowed witnesses, and it's a very powerful tool in finding people guilty or innocent. They also have physical evidence. That's what comes out of the forensics laboratory or out of the clues that the policeman might have found. So the thing about witness testimony is that it's very easy to understand. What he saw happen, everyone can understand. When he says this is what happened, very easy to interpret. Problem is, he might be making a mistake. He might have been fudging some ideas that he said he saw, but really he didn't. Or maybe he saw something like it. He might even be biased. He might even hate the person. He might even be lying. Well, you never know. But still, witness testimony is accepted in a court. There's also physical evidence. Now, this is difficult to interpret. You have a DNA chromatography report, or you have some bullet analysis, or you have toxicology results. You have them, but it's not easy to interpret. However, these are facts that are based on science and devices and tests that have nothing to do with people, that are just subject to the rules of nature, which don't change. It's not subject to human error or bias, but it's difficult to interpret what these results are. So very often you use both. You use the physical evidence because you know it's true, and the witness testimony because it's very easy to understand. Physical evidence does have the drawback that there are people who are working on the devices, and people are working on the machines, and what if the people are falsifying their evidence? Okay, that's usually not true, but if you follow the protocols as people, they're not suspected of that. Or if they're recorded as doing the correct thing, you don't have that. Therefore, we often both of them together are used to cause a conviction. The problem with physical evidence, as mentioned, is that it's not easy to interpret. So who's the one that explains the results to the court? This is called an expert witness. Now, the physical evidence is certainly brought to court for the courtroom to debate and to try to figure out what it means, and is based on scientific principles. But what physical evidence is allowed? This was one of the earlier decisions as to what kind of physical evidence was allowed, the Fry versus the United States case. Apparently, he took a lie detector test, a polygraph test, and the claim was it doesn't prove anything. So they came up with rules as to when you can trust the science, when you can trust the scientific results. And the rules were that if the science has been established, this is a major thing, if it was established as being used and used correctly, as providing trusted results, then you can use this in a court. And this is admissible in court. And this is something that the jury has to listen to. Some examples of things that are well established are a scale to produce weight, to define the weight, IR, that's an infrared spectroscopy, chemical analysis, again, that's well established, fingerprints, these are well established. They've been written in the scientific literature for a long time, and therefore they can certainly trust it. What about psychological profiles? That's an interesting question. Have they been established as providing trusted results? Well, then you can actually trust it. But can you really? Anyway, this is what they concluded. that if it's well established as being true, as based on science, then it can be admitted in a court and must be listened to. What if the device can be trusted, but it's just not well established because it's a new device? We need to hear about this from an expert witness. So they did have a case like that. The expert witness presumably is someone who knows, has the technical knowledge to explain the science and to show that the science can be used, whether or not it's well established. They developed this Federal Rules of Evidence, Rule 702, that's what it's called, that you can trust an expert witness if his testimony is based on facts and there are reliable scientific principles, and the expert witness has used these facts and principles in a way, and he explains it in a way that's trustworthy. This is more flexible than the Fry case, because that said, no, it has to be established in the scientific world. Anyway, in court, this was established in the case of Dobert or Dobert, whatever his name is, versus Merrill Doe Pharmaceuticals, where they said that Rule 702 for federal cases should be followed. Now, this is a federal rule, but it's usually followed by the states because it does make sense. And it also establishes that it's the judge who has to decide whether the scientific evidence is admissible. The judge has to do his homework. He has to know what the scientific results are and what causes the scientific results. The questions that the judge has to be asking is, has the theory behind the method been tested? Maybe the method is new, but does the theory, does it work? Should it be worked? And do we know that it works? Does the theory trusted among the scientists? And nothing is perfect. What about the rate of error for the method? Is it very reliable, 99% reliable, or 80% reliable? How reliable is that? Was the technique used in a responsible way? When the people actually did this technique, this new technique, was it done in a very reasonable and a very responsible and accurate and good way? He's got to know that. He's got to ask these kind of questions. He's got to learn that before he admits it. He admits the evidence in court. And have there been published accounts of at least the theory? Maybe the method that they're using is a new one. Have they analyzed the theory? And have there been any published accounts? It might not be well established, but there's been one or maybe two very recent published accounts of it that were analyzed by other scientists saying, yes, it makes sense. The judge has to know that. He's got to get answers to that.